Well, I'll confess I was surprised, and I think I was surprised not because I think the opinion was wrongly decided. I think the Florida State Supreme Court did the right thing, but there was some question as to whether we were going to have time to do the recounts at all. And I think that one of the trickiest parts of the opinion is choosing to recount just the undercounts, although throughout the state of Florida. It's an interesting way to give us enough time potentially to do the recount. It's a sort of a partial recount, but it's also statewide. That makes them a little more vulnerable potentially under Supreme Court review. But I think that's what surprised me, because my assumption is that they were going to have to rule on a total recount, and there wasn't going to be enough time to do that.
And very quickly, summarize the Florida Supreme Court's rationale. Why do they do it?
Well, essentially what they're saying is that the will of the voter, the intent of the voter is paramount, that the state legislature has set forth a set of rules that includes this contest process, that by the Bush folks' own admission during the protest period, that was the period before the certification, that in fact the contest period was the time during which we were supposed to, the trial court could get involved and investigate and discern whether or not certain votes had or had not been counted that were legal votes. And their determination was that, in fact, there is significant doubt as to whether all the legal votes have been counted.
Ed McNally, do you agree with that summary, or is there something you want to add?
That's a very charitable reading of the Supreme Court opinion. I don't know if any of us have been all the way through it. It's 70 pages.